Stansfeld, Secretary of State for the Home Department, and the Commissioner for the West Midlands.
Yes, Mr. Payne.
Good morning. I represent the Secretary of State.
Yes, you do.
I was just checking. Together with my friend Mr. Jack Anderson, Mr. James Stainsfield, with Emma who represents the Peace and Crime Commission.
Yes.
Before I start, I'm afraid there's one matter which came to light yesterday, and it's a document that ought to have been disclosed prior to the hearing in front of Mr. Justice Swift. Secretary isn't relying on it, but just for the sake of transparency, it's been disclosed. And what it is in a nutshell.
Mr. Payne, I'm sure the fault is mine. Could you just raise your voice slightly?
I beg your pardon. It's what it is, my lady, is it's a email from DULUC setting out DULUC's view on whether the statutory questions should be included in the consultation.
Right.
So it's something from DULUC, not from my client, and it's not something we rely on. It's just something which we felt that we ought to disclose.
Thank you very much indeed. Mr. Payne, Mr. Stansfeld, can I first of all, on behalf of the court, thank everyone who must have worked very, very hard since Tuesday in putting together the papers for this application. We have a core bundle, we have a supplementary bundle which runs to 386 pages, we have an authorities bundle, and an additional authority came in yesterday. I can say that we have read the core bundle, we have read the updated appellant skeleton argument, which really updates with references to the various bundles. Mr. Stansfeld, thank you, we've read the respondent's skeleton argument as well. I cannot say that I have read every single page of 386 of the supplementary bundle. We've done our best. We know that this is your application, leave having been granted by my Lord, Lord Justice Dingemans, on Tuesday of this week for a rolled-up hearing of the application for permission. And in the event that permission is granted and the appeal is successful, we also know that there are cross-appeals which have been raised in your solicitor's email, and we have that. It seems to us the sensible way forward is in the first instance to hear your application, then to hear your response to it, any reply, and then we will rise to consider the position. So let's move forward on that basis, unless anyone has any objection to it.
No, ma'am.
No, right.
So my lady, subject to the court's views, what I tend to adopt an approach whereby I will take you through what we say are the key documents, just in terms of the Secretary of State's grounds of appeal.
Right.
And then I will deal with each ground of appeal, or both grounds of appeal, by reference to, first of all, the statutory provisions, then the case law we say is relevant, and then the grounds of appeal. So effectively, I won't have a sort of freestanding bit on the law. I will do it by reference to the individual grounds of appeal.
Fine.
So, against that background, you have an agreed chronology of events in the core bundle at page 39. And I'm going to ask you, most of the documents I'm going to be taking you to are in the supplemental bundle. And I am going to start by taking you to the submissions to the Minister on the 22nd of November, which provided the basis for the 6th of December decision. And that document is at page 160 in the supplemental bundle.
116.
160, my lord, yes.
Yeah, thanks.
My lady, do you mind if I just go forward for a second to get to
No, go ahead.
So at page 160 at the bottom, you will see a heading Considerations. And then you have the sort of very short statement effectively saying that the transfer is consistent with the stated devolution ambition and the PCC review. And then paragraph 7, you have a reference to the difficulties faced by the West Midlands Police. And then at paragraph 9, you have a reference to the transfer being supported by DULO. And it was against that background that the 6th of December decision was taken in terms of that advice. Now, the point I make in terms of those submissions are there's obviously no reference to the statutory criteria, because at that time no one was aware that they were applicable. And so it was really a short, sort of punchy submission, which was considered to reflect the long-standing position of the Conservative Party on this issue. Then I was going to ask you to turn to the 11th of December note, which is at... Sorry, I beg on. I was then going to ask you to turn to page 284. Now, this is an email which, if you look at the top, you can see it's dated 6th of December. It is an email that effectively circulating the draft order, and they sent on the day that the your first decision to transfer is communicated to the Mayor and to the PCC. And the point I want to make in relation to this email is you will see that in terms of this, at this time, there was 7 days was being provided in order for comments to come back. And when we go to the email in relation to the second decision, you will see it's truncated. It's to 2 days, and the reason I say that's relevant is in the context of the suggestion that it's an indication of predetermination, when in fact, as Mr. Justice Swift held, it's effectively just time in order to get the drafts sort of sorted out and enable people.
But at the moment, you've won on predetermination anyway.
I know, yes, but yes, that's true. But I just wanted to have that one document to be in your mind.
Thank you.
Then going back, my lord, to the submissions, if I can ask you to turn to 168. And this is an information note dated 11th of December.
To which page? I'm just making a note.
Beg your pardon, my lord. 168. So the 2 points I want to make in relation to this document is, first of all, there's a clear explanation at paragraph 3 as to the error and, in fact, what needs to be considered. But more importantly, from my ground of appeal, is paragraph 5. Because paragraph 5 says, we have not put advice to you in the new statutory test imposed on you by this technical error. And that, we say, is relevant to what was available to the Home Secretary at the date the consultation was issued. Because there is no document between this document and the consultation document which reflects consideration or advice on whether the statutory tests are met, or provides any basis for thinking that the Home Secretary could have formed a view on whether the tests were met. In terms of, in terms again, limiting myself to my grounds of appeal, if I can ask you to turn to 209. Now this, not very sort of clearly explained document. It is, as you can see from the top, it's a sort of briefing note made to respond. If you could read the top paragraph, made in response to a request from the policing minister. If you could, it is in fact issued. This note is issued on the 24th of January, 2024.
Sorry, can you give me the page number again?
My lord, yes, 209.
Thank you very much.
And the point of relevance is at 210, the next page. And you can see in the middle it says consultation response so far. And it's just sort of evidence that the process suggested in the 5th of February submissions was ongoing, and that the analysis of the responses was being undertaken as the process went on.
Sorry to interrupt. What's the date of this document?
It's the 24th of January. If you look at under the heading consultation response so far, it says as of 11 today, 24th of January.
All right, so you only identify that in the text rather than at the top.
Yeah, that's one.
Thank you.
And what's the relevance of this document?
It just
the ground of appeal that we're dealing with?
it's the suggestion that in terms of the process that was being adopted, that the responses were being considered as we went along.
So it's round 3 conscientious consideration rather than whether the exercise itself is adequate.
Well, my lord, to be honest, it's 2. It's one that the responses were being considered as we go along, perhaps, yeah. And the second is that the responses are in fact raising and addressing the number of responses and effectively the information that was being provided. I mean, it's dealt with in more detail in the submissions, but it's...
And in a witness statement.
And in the witness statement, but it is effectively, I mean, perhaps it's not an important point, but it's in terms of the suggestion that it wasn't enough information provided, people were struggling. You could see throughout the process, a large number of responses were being given, and as provided in more detail, the main themes of those responses suggest that the relevant issues and criteria were being addressed by those responding. And then, in terms of the next document, can I ask you to turn to the assessment and statutory tests document at page 5.
And this is really the executive summary in the questionnaire, isn't it?
I beg your pardon, I meant to say 26, sorry.
No. Page 5 is the consultation document.
I'm sorry.
Yeah,
26.
Thank you.
And I'm not going to take you through this document in detail for the context of my grounds of this. I wanted just to make one point, which is at 33, page 33. And under the heading, is the transfer of PC functions appropriate? You have the paragraph immediately below says, in order to assess whether the transfer of PCC functions would be appropriate, having regard to the need to secure effective and convenient local authority, we've assessed the way in which the mayoral model works in areas. And again, sentence below it says, to assess whether the transfer would be appropriate, that work has been undertaken. So effectively, the point I rely on in terms of this paragraph is that this paragraph makes it clear that effectively the work that is recorded in these reports was carried out in order to deal with and assess the responses, and isn't an indication that the Secretary of State was, or that the Home Secretary was aware of this information at the time of the consultation, or that it could have been provided.
Well, how do we know that from that paragraph? It doesn't say that it's analysing the consultation responses, does it?
it says, well, it says in order to assess whether the transfer, and then it says we have assessed the way in which the mayoral model works. And then you've got the assessment below.
Yeah. But I thought you said that it shows that they were assessing the consultation responses, and therefore they couldn't have provided this information.
No. What I meant to say, well, maybe that's what I said, my lord. I didn't. What I meant to say was that the work undertaken, which is recorded in the report, in terms of the information obtained to assess the responses, was obtained for preparation of the report, and it wasn't available at the time. Not wasn't available. It wasn't in the mind of the Secretary of State at the time the consultation
Had started.
Yeah.
Because this work hadn't been done by then.
Yeah, exactly that.
Although, as a matter of reality, it could have been. Yeah.
Absolutely,
Yeah.
absolutely. So that you have the advice, which says we haven't done advice, and then this is the advice which was done. As you know, in parallel, the work was being done at speed, and it was done in parallel with it, so as to provide the response and the assessment to the Home Secretary. Now, then I'd like to turn to the respondent's case on this issue. That's in the core bundle. 109. So I think 109 deals with 100 friends ground. So 111 is the insufficiency of the consultation. And then if you turn to 112, you have a reference to paragraph 76 to the issues, in other words, the statutory conditions on which the Secretary is required to consult. And then 77 deals with the claimant's case, on the respondent's case on this point. And if you look at 77, it's all about the failure to ask questions. And ditto 79 is about the failure to seek views. And it was no part of the claimant's case that it was unlawful for the Secretary of State not to have expressed a view, reached a view and expressed a view on whether the conditions were met.
Well, presumably he's not going to go through the rigmarole of consulting unless he thinks potentially a transfer will happen and therefore potentially the conditions might be met. He presumably will have some idea about that, and doesn't he have to tell them broadly what are the issues that indicate that the criteria may be met?
Well, so the Secretary's position is that all that is required in terms of a consultation of this nature is for the Secretary of State at an relatively early stage in the decision-making process to identify potential benefits which underpinning the proposal, identify the criteria he will apply in reaching a decision, and consult.
And this was a statutory consultation, so the statutory context is important.
It is important. It is important.
So what was he actually consulting on? It says the Act says must carry out a public consultation. What was he consulting on?
Well, he was consulting on the proposal to transfer DCC functions to the mayor.
But in a statutory context.
Absolutely. But in that statutory context, there's no indication or provision in the statute or requirement in the statute for a view to have been reached in terms of the conditions, and there's nothing suggesting that there can't be a consultation at a stage when no view has been reached on whether the conditions are met. The Secretary is entitled surely to identify benefits which he or she considers would arise from a transfer or a type of decision, consult on those benefits, obtain the views from the public as to whether those benefits are accepted or if there are additional matters or that might be relevant, and then at the end of the process consider whether the criteria or conditions are met. I mean, if in the statutory context, the focus, we say, is on ensuring that the public are able to participate in the decision making, and to that extent, that doesn't require the public to comment on the views of the Secretary as to why statutory conditions are met. It requires the public to have an opportunity to comment on the benefits, and to do so in the context of their well-being, the things that they think point to or against the transfer, and then leave it up to the Secretary of State to apply the statutory criteria, which is very broad, in deciding whether the transfer should go ahead. I mean, indeed, there's no obligation on the Secretary of State to transfer, even if the statutory criteria are met. So, in terms of decision-making process, the Secretary is perfectly entitled to go through the consultation, decide on the information available not to proceed with the consultation, or decide applying the criteria not to proceed with the consultation.
So the consultation doesn't have to be connected to the criteria at all then. It can be a consultation saying, we're thinking of doing something. Please tell us whether you think this is a good idea or a bad idea.
No, it has to be connected to the criteria to the extent that the criteria that will be applied in the decision need to be set out so that the benefits, perceived benefits are set out. The criteria that will be applied in deciding whether to proceed with a decision are set out, but that they're not straitjacketed in terms of the questions or in terms of the views that need to be expressed in the early stage. I'm not saying that it's not open to the Secretary of State to have a consultation where the views are contained, or his preliminary views are contained in relation to those criteria. But what I'm saying is that there's no statutory or there's no obligation in the statute and no requirement for there to be an obligation that the Secretary of State has taken a view on those criteria before consulting.
Can I just ask you on that point, which I think is the main point of why you're seeking permission to appeal on the ground, how you deal with what Lord Wolfe said in Ex parte Cochrane, which is, you're right, it's not set out in explicit terms in the statute, but the statute says these are the criteria, economic well-being, and you must have a public consultation. And what Lord Wolfe said is that the obligation was to let those who have a potential interest in the subject matter know in clear terms what the proposal is and exactly why it is under positive consideration. And that was a passage that was expressly approved in Moseley. And if that is right, does that suggest or not suggest that the Secretary of State said, I consider this is for the economic well-being because of ABC, and set out his provisional, and they could only be provisional conclusions at that stage?
I think, my Lord, that what needs to be done, and this is consistent with Lord Wolfe's dicta, is that the benefits that in this case, that the Home Secretary considers would arise from the transfer, and the reasons why those benefits are thought to arise is sufficient in terms to discharge the duty in this context of enabling participation of the public in the decision-making process. And it's a combination of Secretary's view on the benefits, sufficient explanation of what those benefits are, knowledge of the statutory criteria that will be applied, and we say, taken in the round, that is sufficient.
Thank you.
Just to have you, when you say benefits, the benefits now are obviously different from the criteria. So the fact that it's likely to improve the economic, social and environmental well-being, or the fact that it's appropriate in regard to the need to secure effective and convenient local government, you're treating those as criteria, and you're saying the benefits about which you have to consult are something different from those criteria. That seems to be the implication of the use of your language.
Well, what I'm trying to say is that the information provided as to the benefits, the perceived benefits by the Secretary of State, combined with an indication, well, combined with confirmation as to the criteria that will be applied in considering that information and information relating to those benefits.
Yes, and sorry to press you with this, just so that I'm absolutely clear in my own mind. You're using words as labels, and I just need to know the content of the labels. When you say benefits, you're referring to a state of affairs separate from the state of affairs referred to in the statutory criteria. Something separate from the criteria, and you need to tell them what those potential benefits are, and they need to have the knowledge of the statutory criteria, but it's the benefits that need to be explained.
Well, the separation I am making between the benefits and the statutory criteria is that the Secretary of State isn't, we say, required to explain by reference to expressly by reference to the statutory criteria how those benefits fit in. So the
benefits are separate from, they must be something separate from the criteria then.
No, not, well, with respect, my Lord, you can have the Secretary of State's views as to the benefits, and on that basis, I suppose, a preliminary indication as to why the Secretary of State considers that those criteria are met. But what we say you don't need to do is you don't need to identify particular benefits which are said to apply to particular criteria.
So in other words, it is left to the individual member of the public to read of the benefits, to read of the criteria and work out for themselves how one may fit in with the other. Is that it?
No, my lady, the public address the benefits.
Yes.
And they don't need to do so under individual headings in terms of the criteria, statutory criteria. They can simply set out their view on the benefits, knowing the type of, well, the issues the Secretary of State will consider, and then it's for the Secretary of State to sort of separate out those benefits and decide whether they meet or where they would fall in terms of the statutory criteria. I only got to the stage when I was just saying what the claimant's case was.
Sorry to ask questions.
No. Can I just find them? So jump ahead then to where? Then, well, I'm going to turn now to ground one then. So I think we've dealt with my initial point, well, the initial point I was going to make through the questions of the court. I was going to make a point that the judge did not accept that questions had to be asked in relation to each of the statutory tests, statutory conditions.
Can I just ask a very technical and boring question? Your grounds of appeal, and I know they were produced overnight because of the urgency of this matter, are at pages 14 to 16 of the bundle. And those aren't the grounds that you then identify in your skeleton of paragraph 5 at page 18 of the bundle. Given that we have to consider your grounds of appeal, I assume that you're happy for us to concentrate on the later grounds. Is that right?
Yeah.
I mean, they overlap. I can see why they've been written as they have, but I just wanted to check that with you.
Yeah, yes, my Lord, I just took a stylistic decision to regroup them. I don't think there's anything new, but I just think it's regrouped.
No, they are more crisply expressed. Thank you.
Well, I won't blame Mr. Anderson for that. So, in terms of dealing first then with section 113, I'm going to deal with section 113 by reference to, or using Mr. Justice Swift's judgment, because he sets it out there, and we don't have to.
And that's the latest version, is it?
Of the judgment.
No,
Yes,
because section 113 has changed,
yes.
and that's created lots of issues, but that's the latest version.
It is, yes, my lord, and it's at page 49.
Thank you.
And it's paragraph 6.
My lord, yes. So, we've all looked at the tests in terms of A and B. There is only, one point of perhaps to note is that A requires the Secretary to be satisfied or can consider that there's likely to be an improvement, whereas AA is a sort of slightly more nebulous consideration of appropriate, which is perhaps harder to define and seek views on. In turning over to page 50, section 2 we say is an important subsection, and you can see there the duty to consult. So the duty to consult unless a proposal has been prepared under section 112A, a public consultation has been carried out in connection with the proposal, and the Secretary of State has been provided with a summary of those responses, and the Secretary of State considers that no further consultation is necessary. Now, why we say section 2 or B is important is that it provides for a consultation which is not undertaken by reference to the section 113 conditions or criteria, and it provides that the Secretary of State can think or can consider that consultation to be sufficient. So section 113 clearly envisages a consultation process which where there can be reasons given in terms of the conditions or where they can't. Because if it's a mandatory obligation that there needs to be a consultation with the views, where the views or preliminary views at least of the Secretary are set out, then there would be no discretion effectively as provided for under section 2C.
2B, there's been a public consultation in connection with the proposal, which rather makes me think that the opening words is carry out a public consultation on the proposal or on a proposed or potential transfer. And it's got to be a proposal to make an order, and you'll only be able to make a proposal if it's likely to improve the economic, social, and environmental well-being. So surely you're not going to make a proposal, are you, if you're the Secretary of State, unless you've considered how, if at all, it's likely to improve the economic, social, and environmental well-being of the area?
Well, yes, so the Secretary of State, if the Secretary of State accepts the consultation that's been undertaken, so not by him but by somebody else,
Yeah.
then the Secretary of State will of course apply those criteria in reaching the decision.
The proposal has got to be, surely it's a proposal that's connected, whoever makes it, and if we think about what the statute says, there's going to be a proposal for what? A transfer of function. Why are you transferring functions? Well, it's likely to improve the economic, social, and environmental and well-being. Well, what's your information on that? Whoever's asking it, surely the proposal, given that it's a proposal to make an order which does certain things, or is likely to do certain things, however it emerges, doesn't the proposal have to be connected?
Well, I mean, my lord, without risk of repeating myself, if no information was given which enabled those criteria to be considered, then that might render such a consultation deficient. But Secretary of State's position is that by setting out the benefits which the Secretary of State considers would be derived from the proposal, then that is sufficient in terms of the information needed to consider for the public to consult. I mean, if I can maybe put it this way, is that Mr. Justice Swift accepted that some of the benefits that were identified were relevant to the criteria, and indeed, inevitably so. Mr. Justice Swift also accepted, and we endorse, the fact that the well-being criteria are incredibly broad. So, considered in that context, identifying the benefits which the Secretary of State considers would follow through from the proposal and the benefits for the local people who live in the area and policing, those are the matters which fall to be considered under the criteria. So they do, in effect, albeit not criteria or condition by condition, that is in effect providing the Secretary's view in broad terms as to the benefits that arise and the issues that he will consider in determining whether they are sufficient to make the order.
That's why I wonder whether it's better not to use labels like benefits and criteria, and the substance of the consultation is information that's relevant to why the functions are being transferred, arguably should be provided.
But I think we would accept that the information relevant. It's just what we don't accept is that you need to separate that information out and sort of by reference to the sort of different or individual conditions. We don't accept that you need to disaggregate the conditions and ask questions in relation to each specific aspect of the conditions.
Can I just ask you a question on subsection 2? You reading A, B, and C as disjunctive or or conjunctive? Because I think you just emphasised C, but that has to be read with, because B ends with an and.
My Lord, yes.
Yeah, so there must be a public consultation unless you're in section 112A territory. There's already been a public consultation, and then the Secretary of State considers there's no further.
Yes.
Yeah.
Yeah. So absolutely. So the Secretary clearly has a discretion, but the point I was trying to make was that if the only way the Secretary of State could lawfully consult was by reference to his views or her views as to whether the conditions were met, there would effectively be never a situation where the Secretary of State could accept a consultation which had been undertaken without those views having been set out.
Thank you.
And then if you look at the paragraph at the bottom of the page, Justice Swift's analysis, you can see there that there's a sentence that starts, nevertheless. The amendment made to section 113 of the 2009 Act required the Home Secretary first to be satisfied that the conditions in section 113(1)(a) were met, and second, to carry out a public consultation. And whilst that's obviously correct in terms of the order it's set out in the statute, we say that there's nothing to infer from that, or from the order in which they appear in the statute, and there's nothing to suggest that there needs to be a decision or that the Secretary needs to be satisfied that the conditions are met before carrying out the public consultation.
But I thought you said he was going to consult on a proposal to transfer functions. And would he make a proposal to transfer functions if he hadn't even addressed the question?
Well, you can see that that's what happened in this case. And we say it's not Wednesday unreasonable for the Secretary of State to take a proposal and benefits that have long been thought derived or would arise from a transfer and consult on those benefits and consider at the end of those benefits which are considered to inform the criteria whether in fact they are met. Alternatively, even if not sort of articulated or formally recorded as such, the benefits that are identified in the consultation paper are those that are considered to potentially satisfy the conditions. And then can I ask you to turn to page 56? And at paragraph 21, Mr. Justice Swift refers to the need to consider the context, and obviously statutory context, we entirely agree with that. But what we say needs to also be considered, in particular, when the statutory context provides for a consultation in relation to a range of decisions, is the nature of the decision that is proposed to be taken. And I'll come back to the nature of the decision when we look at the consultation paper. And at paragraph 23, my Lord Justice Lewis has already sort of asked me about the point that's made about the obvious connection between the conditions. You have my submissions on that point. But then Mr. Justice Swift goes on in the middle of that paragraph to refer to, put another way, Section 11 may be seen as plotting a sequence of events when the Home Secretary, in exercise of the discretion of the 107F power, proposes to reorganise arrangements for local democracy. First, the Home Secretary considers for himself the reasons why the two conditions are met. Then there's a public consideration of those reasons. And then ultimately there's a decision. And we say that there doesn't need to be a focus on whether the conditions are met prior to consultation, but there does need to be a focus on the benefits that are perceived to arise and which will be taken into account or may form the basis for the Secretary deciding that those conditions are met.
Paragraph 25, anything wrong with paragraph 25?
My Lord, beyond the point that the Secretary is not obliged to disaggregate the conditions, we say that providing evidence as to the benefits, perceived benefits, which ultimately will, depending on the outcome of the responses, but it is proposed, will form the basis of the assessment is sufficient. And we say that the Secretary of State's approach is actually supported by Section 112A as opposed to undermined by Section 112A. And Mr. Justice Swift deals with that at paragraph 24. In fact, can we turn to 112A before I take you through paragraph 24?
This is authorities bundle.
My Lord, yes.
Thank you.
And it's page 17. So at page 17 at the top, paragraph 1 says, the one or more authorities may prepare a proposal for the making of the order and submit the proposal to the Secretary of State. And it applies as you can see, paragraph 2A, combined authority. And then paragraph 3 says this: before submitting a proposal under the section of the Secretary of State, the authority or authorities preparing the proposal must carry out a public consultation across the area. And then it says, have regards to the consultation in preparing the proposal for submission to the Secretary of State. And we say that that supports, that's the sort of process which we say should apply in terms of a section 113 consultation. That there's no requirement or indication that as to the particular stage in which consultation needs to take place, or what needs to be decided, or views need to be informed when the consultation takes place. All that needs to happen is when a proposal is being prepared, at some stage during that process, presumably when one looks at the case law, after it's beyond, when it's beyond the inchoate phase, and there is at least enough information to enable an intelligent response and participation, the consultation can take place.
Are you submitting then that any consultation under 112A3 wouldn't need to grapple with the 107F conditions?
But there's certainly no requirement to do so.
Yeah. Okay. Thank you.
I mean, if you were, my lord, if you were a combined authority and you were looking at section 112, you're saying, well, these are my obligations that I need to undertake. There's no indication at all that you then need to go on and consider what the Secretary of State might have to consider, or would have to consider, if ultimately your proposal is accepted.
Except, I suppose, the contrary argument, which I think the appellants have put to you, so I'd just like your answer on that, is that if you look at 112A1, which refers to 107F, and then when you look at 113, in order for the Secretary of State to make an order under 107F, those matters are then set out. So, it might be thought that you probably have to. I mean, it's not easy to follow because, as you rightly have already pointed out, the statute was not necessarily entirely thought out when it was put together. So it's a bit difficult to work out, but that's really why I want your submission on it.
No, yes. My submission on it is that it is not for the local authority to try and second guess what the Secretary of State's view will be on the statutory conditions. The local authority is entitled to make a proposal, consult on that proposal, and then put it forward to the Secretary of State for the Secretary of State to decide whether there's enough information.
But the proposal is still going to be a proposal under 107F, under 107F, and for the Secretary of State to make a proposal under Section 11F, and he can 107F, and the Secretary can only do that if it's going to be likely to improve the social and economic well-being of the area. So when they're making a proposal, surely any rational combined authority or local authority is saying, well, what are we doing here? We're putting forward a proposal and asking the Secretary to make it. They're not going to do that, are they, unless information is available and considered about whether it's likely to be capable of meeting the condition. They're not going to put forward a proposal to the Secretary of State saying, we've given no thought at all as to whether or not you could make this proposal, but we think it's a jolly good idea. We've asked people and they think it's a jolly good idea. They're not, it's just not how the section expects it to work, is it? Not
Well, my lord,
proposals in the abstract, it's proposals in the context.
but my lord, the Secretary of State, sorry, the combined authority would be entitled to think about a proposal. I mean, obviously, it's not just 107F. Yes, it's a range of decisions.
Yes.
They'd be able to think about a proposal, think of the benefits that the combined authority considers would arise from it, make clear ultimately what the Secretary of State's criteria are, and consult on that. And if you look at the structure, it's not only the proposal is, as I said, the proposal can be consulted on at any stage during the preparation of the process, and after the consultation, it is then for the combined authority to consider what proposal to make, if any, to the Secretary of State. So if you look at
The implication of 112A1 is that they prepare a proposal, and which means they've got a proposal, which is something that's going to translate into an order, and then 1112A3 before submitting a proposal. So that seems to me to make it clear that a proposal has emerged. They're not consulting on benefits in the abstract. They're consulting on a draft proposal.
Yes, my lord, and then if you look at 3B, you then see, having regard to the results of the consultation in preparing the proposal for submission. So you can have the consultation before the proposal obviously is finalised, and the Secretary of State must get under 113, must get the responses to the consultation.
In preparing the proposal for submission, what they're talking about there is you've got a proposal, a draft proposal, call it what you will, but there is something in substance that is relating to the power. You consult on that draft proposal, or the thing you want to turn into an order, and before you submit it to the Secretary of State, you consult. So it's proposals, consultation, final submission, which may or may not involve changing the draft proposal. But it's not in the abstract, it's tied to the statutory provisions, isn't it?
Well, Lord, I mean, it isn't in the abstract, like I said. But, my lord, the combined authority can't comment or really express a view as to what the stance or the view the Secretary of State will take on the conditions.
No, I understand that, but can they not at least provide information on why they think the proposal is likely to be made, i.e. information about why they think the conditions are going to be satisfied?
My lord, they could and they can, but what we say is that it's not unlawful for them not to. I mean, ultimately, my lord, if the information that's provided and the responses that are provided are accepted by the Secretary of State, even without the combined authority having expressed a view on it, then the Secretary is satisfied that he has enough information to decide whether the conditions are met. And we say that that doesn't require the combined authority to have expressed a view on whether the Secretary of State thinks or will think that the conditions are met. And if the Secretary of State considers that there is insufficient information or insufficient questions have been asked, then obviously it's up to the Secretary that has the option of reconsulting. My lord, can I also just go back to the sort of the other point about both about section 112A and section 113, is that the Secretary can rely on a consultation that's been undertaken without any reference to section 112A or section 113. And those consultations clearly would not have set out the conditions the Secretary of State has to meet.
So how can he do that?
Well, he can do that if you look at section 113, and you look at section 113 2B.
Yeah, and that's a proposal, and that's a reference back to a proposal prepared under section 112A.
No, yep, and then B, my lord.
Yeah, but your point is, I'm not following it.
Sorry, section 113 2B enables the Secretary of State to accept a consultation that's been undertaken without reference to section 113 or section 112.
Well, it's a public consultation that's been carried in connection with the proposal. What is the proposal? A proposal has been prepared under section 112A. You go back to 122A and you ask, what type of proposal under 112A is it? And if it's a proposal under 122A, the making of an order under 107F, then you're right back to where you started, aren't you?
Well, my lord,
1132A to C is if the Secretary of State will have enough information about the proposal by another route, then he doesn't have to consult about the proposal himself. That's what it's saying.
but my lord, then that depends on what you take the proposal to mean, because you can have had a proposal. If the proposal is, for example, simply to transfer the PCC's functions, then we submit that, as I've talked about, the Secretary's position on that is the proposal can be made without reference, certainly by the combined authority, to the conditions or the likely view of the Secretary of State of whether the conditions will be met. And in terms of going back to section 112A, paragraph 9, what is said, and this is when it's passed over to the Secretary of State, a proposal on section must specify the purposes. So again, there's no indication that the proposal needs to contain any form of view as to whether the statutory conditions are likely to be held to be met. It's simply the proposal. So I think really the distinction the Secretary of State draws is, the Secretary's position is not that the views or the likely views as to the conditions, statutory conditions, whether they are met, cannot, or even in many cases, should not be referred to. The Secretary's position is that they don't have to be referred to in order for a consultation to be lawful. Because I think it must follow that if they have to be expressed, or view has to have been reached on the conditions, then it's difficult to see how this consultation can have been lawful. Because, and the Secretary makes no bones about this, a view hadn't been reached as to whether whether the conditions would ultimately be met.
Well, I thought you had a fallback submission, which was, if you look at the consultation paper, there was sufficient expressed there to show that those conditions had been met.
Oh, absolutely, but it was just that if there had to have been the Home Secretary had to have had a view.
Yeah.
But absolutely, we say that the information provided is the information that the Secretary would think is likely to be sufficient to meet the statutory conditions.
I'm sure you're going to be coming to it, Mr. Payne, and I do not want to take you out of where you are in your submissions, but at some point you will go to that executive summary and address the content of it.
The consultation. Absolutely.
Thank you.
Can we go back to the Justice Swift's judgment? We say that the judge sort of envisaged or imposed, in fact imposed effectively a three-stage process in when undertaking section 113 consultations.
Well, when you say that, is that a reference to paragraph 23?
My lord, yes. Sorry, my lady, yes.
And so when he uses words such as, put another way, section 113 may be seen as plotting a sequence of events when the Home Secretary and then goes on, you are saying that amounts to an imposition?
Well, we're saying yes, in terms of it being a mandatory process that needs to be adopted, and we say it's not reflected in the statute.
No, forgive me, I am being pedantic now, but are you saying that simply those words, put another way, section 113, may be seen as plotting a sequence of events, that imposes a mandatory process? Well,
insofar as the may, if may means just an option or a sequence, an approach, then we have no issue with that. If, on the other hand, the may is interpreted as effectively saying must, then we do say that's a mandatory process which isn't provided for in section 113.
And you don't like the third sentence either, do you? Whatever the consultation might cover it ought to provide the occasion for consideration and comment on the Home Secretary's reasons why the conditions are met. You say that's too high.
Yes, in terms of disaggregating the conditions. I suppose at a certain level, what the Secretary is saying is that, in terms of, insofar as Mr. Justice Swift is suggesting a sort of a level of formality in terms of the process, that not only does the Secretary of State have to identify the benefits that he or she considers would be sufficient for the conditions to be met, but rather the Secretary has to actually identify, by reference to each of the conditions or the conditions, why he considers that condition is met. That is what we say is not correct.
Are you saying that when you read 23 and 25 together, the occasion for consideration and comment of why the conditions are set out are met, and then 25, regardless of how a proposal for a transfer of powers comes forward, the expectation is that there will be an opportunity for members of the public to express their views on the reasons for using it. It's not so rigid as that, as my lady suggested. It is just, he's trying to put into words a core thought. If you are going to make an order under this section, which involves likelihood of improvement in certain matters, then people need to be told why you're proposing to do that so they can comment on it. Isn't that what he's saying?
Well, insofar as that's what he's saying, that simply the inability to comment on the reasons why the Secretary is proposing or considering to make the order, then I think that must be correct. I mean, that's the transfer, the reasons why he's considering transferring.
The reasons must include why it's likely to improve, otherwise there isn't a power to make the order.
No, and that, absolutely. So in terms of the likely to improve the well-being, those are the, if it's just that at a pretty broad level, then absolutely the Secretary of State would accept that and would say that the reasons given meet that criteria. No, I won't use the word criteria. Are sufficient. Now, if I can then turn to the statutory consultation. And that's at, starts really at 248, 249.
So 248, 249 what?
Sorry, the core bundle, my lord.
Core bundle.
And the starting point, we say, is to focus on the decision that is being proposed. And we would sort of contrast this type of decision, or the decision that was being consulted on, with the decision, for example, considered in Moseley. Moseley, of course, considered a reduction of, or potential reduction of financial support, which would have a huge impact on the lives of those who are most vulnerable, and has a direct impact on their well-being. Here, what is being consulted on is effectively an operational reorganisation. And the essential point that was being consulted on is whether combining the roles and services provided under sort of one person, so one person with oversight and responsibility for a range of services, gave the opportunity for a more collaborative, joined up outcome in terms of securing the effective, efficient police services. So it's the potential benefits are at a relatively, we would say, relatively high level of abstraction. It sort of relate to matters like democratic accountability, and it can be contrasted with consultations where there is a very clearly identifiable benefit or loss. Because the essence of the objective, the precise consequences are not known and cannot be known until the individual mayor, who might, if the proposal was followed through, might have those powers, decides how to exercise those powers. So this consultation really was about an opportunity as opposed to an action that had clearly identifiable and foreseeable monetizable benefits or an potentially adverse result, such as closing a care home or a hospital. And so when you're looking at or considering whether enough information was given, it is in that context that it needs to be viewed, or the consultation paper needs to be viewed. So in terms of, and I'm going to focus first on benefits. So paragraph, I'm going to use the numbering that Mr. Justice Swift did. I don't know if you numbered the paragraph. But paragraph 3, which is the one that starts the Cities and Local Government Devolution Act. And you have a reference in the middle to part 1 of the government review into the role of the PCC, cemented the view that bringing public safety functions under the leadership of a combined authority has the potential to offer wider levers and a more joined-up approach to preventing crime.
What are the wider levers?
The wider levers, my Lord, and I'll take you to paragraph 7, the wider levers relate to his ability, potential ability, because he's responsible for a wider range of functions, to ensure that, or to coordinate progress. And in that context, the wider role of the mayor is explained a few sentences below, that the mayors have public safety, responsibility for public safety and improving public health. So there you have, although Mr. Justice Swift said there's no indication as to what was meant by that, there is an indication in the same paragraph as to the role of the mayor. And in terms of responsibilities, it's readily or reasonably obvious that how public safety and policing, combining that responsibility, can be or could be beneficial depending on how the mayor discharges his functions. But the point is made even more clearly if you turn to paragraph 7. Now that's at the next page, and if you're counting from the top of the page, it's the third paragraph down. And what is said is this: the transfer presents opportunities to align police and crime priorities with transport regeneration and skills, and to improve the outcome for the public. So again, pretty clear statement as to the potential benefits of bringing things together, bringing oversight and responsibility together.
Well, you say it's a clear statement. It's a very broad statement.
It is. No, I accept that, my lady, and I accept that all these statements are broad. But that is because we're talking about an opportunity. We're talking about what the bringing the roles together, the opportunities that they give rise to. So we're not able to say, well, what the mayor will actually do with those powers. It's just really the opportunity that a mayor would have in discharging effectively multiple functions together. He could choose to align the police and crime priorities with transport, which could be beneficial and improve the outcome for the public. So the Secretary is not in a position to say it will be beneficial to the public because it depends on what the Mayor does.
But the actual decision that was made seems to have been, and no one challenged that on a basis other than the consultation, seems to have been, if you combine these, you save quite a lot of money over a 10-year period and you accumulate that. And that could have been put in the consultation paper together with the contrary arguments, which is, yeah, fine, you might save money, but the local authority won't get any help in funding an election. And in West Yorkshire, the police have found that they're not able to access some central government funding. And what was wrong with putting that in this consultation document?
Well, in a nutshell, my lord, this has nothing to do with cost savings. So the entire...
Well, I'm only going on what was set out in the statutory assessment, as it were, which did factor on those cost savings. I mean, Mr. Justice Swift said you shouldn't have been so narrow, perhaps right, perhaps wrong. But I mean, if one's looking at that aspect of the decision making which took account of cost savings, what was wrong with at least sharing the workings?
Well, my lord, I suppose there are two matters, my lord, that in terms of the purpose of the bringing the PCC and the Mayor together, and I'll repeat myself, but it isn't at all cost-driven, and it's not those benefits. And I will show you documents which make that clear. But I suppose that the second point, my lord, is if you look at the cost savings that were identified in that document, they are £600,000 over a 9-year period. So if you divide that up per year, I can't do it now, about £80,000 in the context of a budget of 1.2 billion, and in the context, again, the documents, I can take you to the document where it says in the document, a population of 2.9 million. So it really is, we would say, a totally peripheral issue. And moreover, in terms of that £600,000, which is identified in the document, that is a saving for the police, which would benefit the local inhabitants.
I'm beginning to wonder whether from paragraph 5 onwards, you need to remember the statute. I asked you at the very beginning, 1132 says the Secretary must carry out a public consultation, and I asked on what, and you said a proposal. And you look at paragraph 5 at the bottom of page 50, at 250, the Secretary seems to think there are 3 things. Before making an order, he must conduct a public consultation. He doesn't say on what. Consider that the transfer is likely to improve the benefit and so on, and consider it's appropriate. So he says he's got to conduct a consultation, and then he's got to consider criteria. And then you look at the next thing, the Home Secretary is therefore gathering views to allow him to make a decision on whether to lay an order. And I just wonder whether, missing from this, and what Mr. Justice Swift was driving at, is by definition, the statute considers there's going to be a proposal, and as you agreed, there's consultation on that proposal, and the proposal necessarily involves some sort of assessment as to whether the right criteria is met, otherwise there'd be no point in making it. And it's not gathering views on whether to make a proposal, it's gathering views on the proposal. And I just wonder whether this isn't a pre-consultation exercise rather than a consultation exercise. Anyway, you're telling me that that's not the right way of reading it.
Well, my lord, you've guessed my response, but might I try and make a slightly less facetious response? 251,
yeah.
I will come back to it. You can see that directly above the question, you have what the Secretary of State needs to be satisfied of. So it isn't that it's tucked away somewhere in the executive summary. You literally have it right above the question, the conditions that need to be met, and then you have the question. So we would say that this isn't a sort of pre-consultation. It's very much a consultation as to, and it makes it quite clear that the criteria that need to be met. And it's obviously up to the person consulted whether they want to raise broader issues or whether they want to raise matters by reference.
just remind me, has the Secretary of State decided that he's going to make a proposal at the stage that he's consulting, or is he not yet of the view that he is going to make a proposal, and it's gathering views about whether or not there should even be a proposal?
Well, my reading of paragraph 6 is that it's to allow him to make the decision.
The decision being?
As to whether to transfer and whether the statutory
The
conditions
decision to
are
make
met.
an order.
So that to me suggests, well, first of all, just in terms of predetermination argument, it suggests that rightly that it is so certainly a final decision hadn't been taken. But really, what's being sought is information relating to which does include information relating to the criteria to enable a decision to be taken.
Doesn't that make it worse for you, though? Because if it is to allow him to make a decision, in the sense of to make an order, he's got to form a view on the statutory criteria. And how can people respond and give him their views on whether to make a decision, whether the criteria would be met, if he doesn't give them any information about the criteria?
But he has given them information about the criteria, and then he's given them the information which he considers, well, his preliminary view, or the preliminary view is that that information would meet the criteria.
So when you say that, are you referring to paragraph 5, where, although there's, yeah, that's it, is it?
No, the paragraph 5 just sets out the statutory test.
Oh, that's it, yes.
Yeah, but the information is, which I was taking to, was paragraph 3 and paragraph 7.
So 3 and 7, you say, set out the benefits.
Yes.
And he's just consulting about those benefits. Those benefits are not a manifestation, a description of things that meet the statutory test. They're separate benefits. And at this stage, he's saying these are the benefits, joined up policing in collaboration. I now need to decide whether or not that would meet the statutory test. So you give me the view about the benefits, and then I'll go away and decide whether the statutory test is met. Is that how you submit this document should be read?
Yes, well, I submit that the document should be read as providing the Secretary's views as to the benefits of the transfer, plus the criteria that he will apply in taking that decision, and inviting
Comment
the
on
views.
the benefits so that you can feed them into the...
And it can be done. It can be done by reference to, the consultation can be done by, or the consultee can reply by reference to the criteria, or they can just provide their views as to those benefits, or whether there are downsides or other benefits not thought of, which are relevant to the criteria that need to be considered. So I'd only read out to you the first sentence of paragraph 7, but obviously you've read the rest of paragraph 7 because, again, one of the criticisms of 3 was it wasn't clear really what joined up meant, and then you have in the second sentence you have an explanation of joining police and crime with oversight. Other public services would also promote further collaboration within the region, and then the last sentence refers to direct accountability in securing an efficient and effective police service in the West Midlands. Now, there's another point which I wish to make, which is that although Mr. Justice Swift focused on sort of the positive benefits that would arise from the transfer, I think it's also important to note that the consultation makes clear or explains that there are also adverse consequences which won't arise. And if you look at paragraph 10, the page at the bottom, and paragraph 9 and 10, you can see how, in terms of maintaining democracy or the democratic aspect of it, the Secretary is saying it's there, you've still got a publicly accountable person who can be held responsible. So although not a positive benefit, it's saying, well, you don't lose that by reason of the transfer. And then he's also saying, well, you've also got an independent panel that will scrutinise and that's at the bottom paragraph, the action. So there's a double level of accountability, and the Secretary is saying you don't lose that either.
That's not the reason why he's doing it, but you won't suffer by having it.
Yes, that's right. So it's and then just turning back to page 249. There is criticisms made in terms of the reference in paragraph 3 to documents and the absence of information provided in relation to the views expressed by the Secretary of State as to in relation to the transfer in terms of other authorities. So if I can deal with paragraph 3 first, and the reference suggestion that effectively a link needs to be provided to the white paper in order for that to be sufficient. We say in the modern world we live in now, with everyone having access to the internet, looking up or considering a document with Google doesn't involve a treasure hunt, which is what was suggested by Mr. Justice Swift. It's a readily, a very easy step to take, and
That
certainly
depends
not
on
a step.
Forgive me, but that really does depend on a person's skills and abilities.
Miley, you have my point on that. I mean, we say just inserting these words into Google doesn't require particular skills.
Which words would you insert? Government review? And as a result,
I'm going to come to the government. I'm going to come to the government review just in a moment. I'm just focusing on the levelling up white paper.
And what about? I mean, the courts have to confront this, which is those who are digitally excluded, and that isn't an insignificant part of the population. It's plainly not the majority. And what about those? Well,
there are helplines that can be given in the document, which people can contact, and there's also an email address, but that would run into the same problem if they were. Yeah. But
when Parliament said you must carry out a consultation, Parliament meant and do it digitally and provide help for those who are disadvantaged. That's what Parliament intended, because don't forget this is what Parliament has required.
My Lord, yes. The Secretary of State, just in terms of the document itself, obviously put it on the website, but also took steps to ensure hard copies were available to be, which could be picked up from various public offices.
No, but these are the documents that you say contain the key descriptions of the benefits. The government review, going on about potentially wide levers and joint up approach, and the levelling up white paper, assuming there's only ever been one, the leadership role the combined authority mayors have. So if I wanted to work out, well, what are the benefits actually, I'd have to get both of those documents, and Parliament thought it was quite enough to refer generically without even giving proper references to those, in the hope that people will either be digitally enabled or will go to a helpline in the time available, and the helpline or the help people can sort them out. And that's what Parliament intended when it said the Secretary of State must carry out a public consultation.
Well, the reason I haven't been touching on the government review is that it isn't published.
Oh, well, how are they going to know about it?
Well, that's why I said, and it's actually, if you look at my submissions in terms of Mr. Justice Swift's judgment, I made the submission in relation to the levelling up white paper.
Oh, not the other one, then?
No, because I accept that one isn't available.
And this was also a consultation done under expedited time limits, wasn't it?
It was, Mike.
And those expedited time limits included Christmas and New Year, and people may not have had at the forefront of their minds the executive summary of the consultation paper.
Well, absolutely, Molly. But to be honest, since it's not accessible by the public, it's not something that they could really have looked at. And then in terms of the paragraph 4 and the reference to, or the suggestion that the Secretary needed to express a view on effectively how the transfers had taken place and whether it was a good or bad experience. we say that's far too onerous an obligation. The reference there is to simply to the fact that it's happened in other places. And as you will see when we look at the consultation responses, people did say that, or did refer to what was happening in Manchester and other places as a reason for and against the transfer. But it can't be said that it's unlawful, we say, not to have provided the Secretary's view on how those, or the experiences of those other transfers. Also, I mean, there is a risk, and I'm sure the claimant would have criticised the Secretary if only some, but not all of the information had been provided, or in terms of the views. So the Secretary just provided his views as to why it was a good thing and the positives, without identifying the negatives. That would have been subject to criticism. So it is a difficult balance to carry out, but it's well within the Secretary's discretion just to refer to the other areas, especially, you know, in terms of Manchester, which is obviously very close to the West Midlands. And as you will see in the responses, people are aware of what's happening in the West Midlands, and as I said, in Manchester, and refer to that as a good reason or a bad reason for proceeding with the transfer. So, unless you have any sort of further, any questions in relation to the consultation paper, that's all I was going to say in terms of the consultation paper.
Dave?
Thank you.
In terms of, then, can I then turn to the sufficiency of information?
Your ground one.
Yeah.
Because I think the time estimate for just your side was half a day anyway.
Well,
I know you've been asked a lot of questions.
My lord, yes. Well, I'll be as quick as I can. So the criticisms that are made of the amount of information, I've dealt with what we say was wrong in terms of page 60, paragraph 28 of the judgment, because we say that paragraph 28 of the judgment, the judge should have considered it with the information recorded at paragraph 33 of the judgment, and considered together, given the nature of the decision that was being taken or considered, that was sufficient, or certainly not so insufficient so as to make the consultation conspicuously unfair. And it is a point we would make that it is unclear from Mr. Justice Swift's judgment what test he applied in considering whether the information omitted or not provided was unlawful by making the consultation radically or conspicuously unfair. And can I just ask you to pick up the judgment in Bloomsbury? And I know it's always the case that the court gets given loads of authorities and then an additional one comes forward.
None of which are referred to.
Exactly.
And then the other one.
And I apologise for that, but
Don't worry, that happens all the time, as you point out.
But actually, there is I think there is a good reason for this, which is that I had thought that effectively the law was agreed between my known friend and I, and then there is in fact a slight issue as to whether it's radically or conspicuously unfair, in terms of, and I didn't want to waste the court's time on it. So my known friend effectively says this is the correct approach in Bloomsbury, and I'm willing to accept that. So that's why I was just going to go through it, so that there's no dispute between my known friend and I, which the court needs to resolve. And I'd ask you just to start at paragraph 65 and read the passage quoted by Miss Carr Frisk from Help Refugees Limited, Lord Justice Hickenbottom's, taken from Lord Justice Hickenbottom's judgment. Justice Bean then says, paragraph 66, it's important to read those comments in the context of the statutory context effective in which the consultation was taking place. But more significantly, he says this, about 6 lines down. The judicial review claim involved an all-out attack on the adequacy of that statutory consultation with local authorities. And he makes the point that it was a similarly sort of, well, not similar, but an attack on the consultation process in the case of Baird as being fatally flawed. And then we go to Lord Justice Sullivan's, the paragraph quoted from Lord Justice Sullivan's judgment. And can I ask you to read from the middle of that? It says, a consultation exercise which is flawed in one or even in a number of respects. And read to the end of that paragraph. And then you have a reference to the Devon County Council case at 67, where Mr. Justice Ousley raises some concerns about Lord Justice Sullivan's dicta. And then at paragraph 68, you can see that Lord Justice Sullivan agrees with the observations of Mr. Justice Ousley, and saying, well, he didn't intend to put forward a different test, but he was just saying what the conclusion that a consultation process had been so unfair would likely involve in terms of findings. And then paragraph 69 refers to the Lord Justice Sullivan's remarks being endorsed in the Help Refugees case, which we saw at the beginning. And then Lord Justice Bean says this, paragraph 69. Firstly, it's not an additional hurdle, which we entirely accept. And then secondly, it is directed principally at cases where a consultation exercise is under attack on such a broad front that it's alleged the whole process is unlawful. And of course, that is precisely the claimant's case in this case.
But it all turns on the facts. I mean, isn't it really? We just got to look at this case and see whether or not it was so unfair that it's unlawful.
But my Lord, one could say that about every consultation case, because obviously every consultation case is decided on its facts. But what Lord Justice Bean, the distinction Lord Justice Bean seemed to be is drawing is between an attack to the entire consultation process, or if you look at the next sentence, an attack by a particular individual who's saying that they didn't receive enough information.
Sorry to ask a really boring question.
Yep.
Is this in the law report? And if so, can I have the citations?
Hopefully it isn't, because I know I should have given it.
No, don't worry. As I say, these things happen. Just so that I've got the detail of it.
My Lord,
Thank you.
It does occur to me that if you're right, and this case was all about a particular subset, the Bloomsbury College, then remarks on consultation exercises that are different are arbitrary.
well, I'm not saying, my Lord, it's a particular. I'm trying to say it's the opposite. I'm saying this isn't about a particular class. This is about the entire consultation.
No, I'm saying, but if this is about a particular class, and it says that's the test for a particular class, then what it says about general ones is arbiter, if you're right. Anyway, I don't think it matters. It's just a case about consultation.
My Lord, I'm happy to say it's not in the law book.
Thank you.
So, but we say the test that the test that should be applied in deciding, which the judge should have applied, although there's no indication as to what test he applied, was that set out in the refugee case and in the case of Bloomsbury. And we say that the correct approach to deciding the test is to recognise that this is a challenge to the entire consultation process. And then in terms of the absence of information, looking down to paragraph, page 61, paragraph 36 says the Commissioner's second point is that the consultation document does not explain that one of the consequences of the transfer of powers would be that WMCA would bear some additional cost arising from the mayoral election. And that's a point made by the claimants. And what needs to be borne in mind in terms of that point is that there was in fact little or no concrete or evidence that could be verified at the time. So the claimant says, or speaking, the respondent says that and relies on the figures, the calculation of the Secretary of State, but that calculation took place at the time the reports were made. It wasn't available at the time the Secretary of State, at the time the consultation started. And in terms, what was available, just give me one moment. Here it is. Thank you. It's 312 and the supplemental bundle. And so this is a note, urgent key decision prepared by the West Midlands Combined Authority. And you can see it's published on the 11th of December, so it was shortly after the 6th of December decision. And the reference to the 13th of December, if you remember, I took you to the document which provided the draft notice, which was to be returned on the 13th of December. And then the key paragraphs are at the bottom. Two paragraphs from the bottom, it says, it is anticipated that. And if you could read those two paragraphs.
So which page are you on? I'm just
312, my lord.
Statutory notice of urgent key decision.
My lord, yes. And so, as you can see, it's a highly speculative positing of a very broad range of figures, with a clear indication that until Parliament makes a decision, we don't know what if any, of the costs will be. And indeed, if you look at page 313, the chair of the Overview and Scrutiny Committee makes it clear that they're not endorsing, or shouldn't be taken as endorsing, this decision. So, from the Secretary of State's perspective, you have a very broad estimate, which is referred to as a possibility, potential, with no indication as to how the figures are calculated and no means of verifying their accuracy. And of course, providing in a consultation figures that are inaccurate risk doing as much damage or more damage than not providing. And as matters turned out, when the Secretary did undertake its consultation, its calculations, the figure the Secretary of State arrived at was 1.3 million, which is obviously substantially less than the 3 million, which is referred to by my claimant in his skeleton argument, and which would have been posited had those figures been referred to. also again considered in the context of the size of the combined authorities budget, the number of inhabitants. This figure, which would obviously have to be considered over a period of 4 years, because the election happens every 4 years, is again a very, very small figure. It's about 300. Well, on their figure, it's about £800,000 a year. On the Secretary of State's figures, it's well, sorry, that's at the top end. On the Secretary of State's figures, it's about 300,000. So in the context of the decision, it is of little or no relevance, and indeed, had it been included, would have been misleading. So the Secretary of State can't be criticised for the non-inclusion of that information. And Mr. Justice Swift said, in relation to that issue, he would not have found that rendered the consultation unlawful. And he made a similar finding in relation to the suggestion that the Secretary of State ought to have taken steps to investigate or provided information concerning the potential additional cost to the police. He did that more in terms of the Thames side challenge, because the potential for looking into the additional cost to the police arose by reason of the NPCC's response to the consultation, so not before the consultation started. Can I then very briefly take you to a point we say favours very strongly the Secretary of State's position, that adequate information was provided. And that is, you need to look at 3 documents. So the first is Miss Chapman's statement, and that can be found in the supplemental bundle. It starts at 224. And if you could turn to 247. And if you could, paragraph 29 refers to the very high number of responses. And then it says this: of the total number of responses, the vast majority, 96%, were able to form a view and answered either agree or disagree to the proposal, with a significant proportion, 83%, of respondents providing a rationale for their view. A small number of responses, less than 50, alluded to not having received enough information. So there is no evidence, we say, in terms of the responses that people felt in any way.
The answer given by the judge, sorry, but the answer given by the judge to that was, fine, they had enough to say what they wanted to say, but they weren't able to comment on the Secretary of State's reasons because none were given. And that was the similar answer that was given in Moseley, right or wrong. And what do you say about that proposition?
Well, my saying in Moseley was that it was really because the alternatives.
Yeah.
Whereas this isn't a case about alternatives. This is a case about whether sufficient information has been provided. But I think when we come to the submissions, the fifth of every submission, which is nearly my last document, what I think is shown by that is you can see that in terms of the themes of the responses, that they address the matters relevant to the criteria. The criterion.
You can never know what would have happened if different information had been provided. It's not a question of numbers or forming a view. It's the cogency of the representations that they make. It's other people who might have made views. You might have had more people writing in and saying this is a good idea rather than a bad idea. And it isn't enough, is it, to look at the adequacy of the consultation on day one by saying, well, a lot of people did reply and most of them thought they had enough to express a view. It doesn't, if the consultation exercise is unlawful, help you, does it?
Yeah, I accept it's not a complete answer, but I think I'm entitled to contrast a position where there's a consultation with very few responses or a clear indication that people found it difficult.
It could have been worse. The evidence could have been, we don't know what you're on about at all. Yeah.
But for example, my lord, if the consultees felt that there was insufficient information, then obviously that's a matter raise, and they could say, for example, the benefits identified in the consultation document, we don't consider they're sufficient. So, given, and I was going to just take you to the 5th of February submission, which is at 203 in the core bundle. Well, if I could just come back to your question, I mean, I think it is a fair point to say that whilst acknowledging you can't tell what people would have done had there been more information, I think it's a fair point to make that there is every indication in this consultation that a lot of people responded and a lot of people expressed views. And when we see here, they express views on matters that are relevant to the consideration of the conditions. And there's only a tiny minority of people who felt they didn't have enough information. Now, I appreciate your point that without additional information, people can't complain. But I'm just saying that in the context of people being invited to express their views on their well-being, the impact of the transfer, there's no indication that they felt prejudiced. Page 204, and if you can read, well, paragraph 9 in present purposes, paragraph 7 refers to the very high response rate. And then paragraph 9, if you go through the various percentages and the themes, you will see that at least 50% of them touch on considerations that are relevant to, if not fundamental to, consideration of the conditions. Conditions. 9. And they actually, refer to the benefits that are identified in the consultation document. And if you look at paragraph 10, you can see that those who disagreed with the proposal also did so by reference to considerations that are clearly relevant to consideration of the conditions. And then if you look at paragraph 12, you can see that having considered the response to the advice was that the benefits which had been identified in the consultation paper, i.e. the rationalisation and collaborative holistic approach, did meet the condition, did meet the first condition. The streamlined, joined up decision making met the second condition. And the third condition, with the consultation have been undertaken, the views of the local, those locally had been taken. So, just going through in the stage. Then you had in the consultation paper, you had the views as to the benefits, which was rationalisation, joined up, collaborative approach. That was the benefit, the reason, which was said to justify the application of the conditions. You have the submission, having looked at the responses, saying, well, those benefits identified in the consultation paper are considered to meet the conditions, and then you have the minister's decision that the conditions are met. Oh, I'm instructed just to make one more point. The case law indicates that in considering the fairness of a consultation, a factor that's relevant is that where it's going to happen is that the ultimate decision that's taken will be subject to parliamentary debates. And in this case, the order has been subject to parliamentary debate, both in the House of Commons, House of Lords, in which any additional concerns can be raised. And as I think you know from the skeleton argument, it's been passed.
Was it negative or positive resolution?
Affirmative.
Yeah.
And I think just for completeness, I think that, and I wasn't entirely sure what this meant, but there was a negative resolution, a motion of regret in the House of Lords where 54. I think but it was 100 and.
I know the detail is somewhere in the papers.
Yes,
I've read it, but I can't tell you where.
Yes, no, well, it is. I would, unless I can be of further assistance, those are my submissions.
Thank you very much.
My lady, my lords, in responding to these submissions, I propose to respond to the first round and then obviously the second one after that. And just, there doesn't appear to be much significant dispute on the law and the legal text. Indeed, my learned friend has accepted that the purpose of this consultation was to engage the public in the decision-making process, which we submit is the principle that one elucidates from Lord Reed's judgment in Moseley. The only case that you've been referred to is the case of Bloomsbury Institute on the test of consultation being unlawful as being so unfair. To the extent that my learned friend seeks to rely upon that as support for a submission that the test is that it has to have something gone clearly and radically wrong, we submit that that's not what Bloomsbury Institute sets out. Bloomsbury Institute affirms that the test is simply that which has always been of a consultation so unfair that it was unlawful, and it's not helpful necessarily to put extra gloss on those words for the risk of effectively generating a different test.
Can I just ask you, while you're on that point, Lord Wilson put his judgment in Moseley very much on fairness. Lord Reed, with whom the others agreed, Lord Kerr agreed with Lord Wilson, put his more just on the gunning criteria themselves. Did that alter the test at all?
My lord, we would submit that if you fail to comply with the gunning criteria, then you have a consultation that's so unfair as unlawful, because the gunning criteria identifies what a fair consultation should include.
Yeah.
And so, in short, my lord, no, but it does emphasise the fact that one doesn't have to scour these documents or scour everything to find something that's gone clearly or radically wrong. One looks at the consultation, looks at the gunning criteria that apply to statutory consultations, and determine whether or not those criteria have been complied with. And if they have not been complied with, then the consultation is unlawful, because those are the principles of fairness that are required. If it helps, we can look briefly at Bloomsbury Institute, but they do cite, as you were referred to, paragraph 67 from Mr. Justice Ousey's judgment of the Devon County Council, where Mr. Justice Ousey made the point that the phrase should not become the substitute for the true test, which is whether the consultation process was so unfair as it was unlawful. My lady, my lords, I can develop that point if it assists, by otherwise responding to my learned friend's submission that in Bloomsbury Institute they sort of reserved the clearly and radically wrong test for where there's been a wholesale challenge to a consultation. assertion that this is a wholesale challenge to the consultation. This is right that we have said the consultation is unlawful on multiple bases. Predetermination, which is obviously our ground of field we may or may not get to this afternoon, insufficiency of information, and then the decision is unlawful for attempts like failure to make proper inquiries. But that is not what we submit the court had in mind when referring to the Greenpeace decision and referring to the Blues Reach decision as a wholesale attack on the consultation. For example, the Greenpeace decision, which is in the bundle, was a decision that challenged whether or not the consultation was even fit to be a consultation paper. My Lord's point, in a way, to my learned friends this morning, that is when one actually looks at this consultation, is it really just a pre-consultation? Because in Greenpeace, the facts advanced in Greenpeace was that, or the argument advanced in Greenpeace was effectively that it was not as a consultation, it was more an initial finding of views. The argument was it wasn't a consultation paper, it was an issues paper and no more. So that is what is meant when it's a wholesale attack on consultation, not simply, for example, here, that it hasn't met the gunning criteria that apply.
I just wonder whether it's simpler than that. This is a statutory duty to consult. Precedent on what? On a proposal. What is the proposal for? It's a proposal to make a change which can only be made in certain circumstances.
My Lord, yes.
Can you therefore decide what's necessary by reference to statutory context rather than generalised concepts of fairness?
My Lord, yes, and I would agree with that. And that was the much succinct point that I was trying to make by saying you can't elaborate that by trying to create a sort of a different description of what the unlawful test is. So turning therefore to the legality of this consultation, and in my submission, the starting point, as Mr. Justice Swift correctly embarked on, is section 113 of the 2009 Act. And of course, as Lord Rees emphasised in Moseley, it is the statutory context that identifies what a consultation should contain. It might help, because it also might help to refer to 112A, to look at it in the authorities bundle. And section 113 is the page 19 of the authorities bundle behind tab 1. And we've already looked at it, so I don't need to go into this in great detail. But of course, section 1 identifies the relevant powers, including 107F, that this section applies to. And then, as we've seen, and sets out the statutory tests at A and AA, and then requires that there to be a consultation is conducted under subsection 2. Subsection 2 obviously provides a discretion, which we'll turn to, not to conduct a consultation if there's a proposal under section 12.112A and the other provisions have been satisfied. But it is evident in our submission that, and in fact, this was argued by the Secretary of State below in response to our predetermination ground, that the Secretary of State is not going to launch a consultation under section 113 unless he is minded to make an order under section 107F. It would be a futile exercise otherwise to do so, no doubt a significant waste of public money and resources. And so if the Secretary of State has decided, well, I am minded to make an order under section 107F, it must follow that the Secretary of State has given thought to whether or not he has the legal power to do so. Because if he didn't have the legal power to do so, again, what is the point of the consultation? And if he considers that he does have the legal power to do so, well, then it follows that he must therefore have an initial view as to whether or not the particular tests are met under section 1131A and AA. And the fact that this is this degree of or at least consideration to the ability to make the power was envisaged, not only is just the one hopes the good administration of justice that those thoughts are given to before spending public money and resources on consultation, but two follows if one looks at my lady and my lords at subsection 2A and 2B. Those are provisions that that relates to an order under section 106. And section 106 is for the amending boundary changes to a combined authorities area. And you'll see there that Parliament envisages that part of that consideration about whether or not to make an order is that the Secretary of State has already determined, or at least got an idea of what the new boundaries would be, and so separate requirements are imposed there. So it just shows that Parliament envisages the Secretary of State when thinking, I'm going to make an order under any of these provisions to which 113 applies, that he has actually in fact turned his mind to that and his power to do it, and whether or not he intends or doesn't intend to do it. And so it is, we submit that Mr. Justice Swift was clearly correct at paragraph 23 of his judgment to conclude that there was an obvious connection between the duty to consult and the statutory tests. And then that connection becomes even clearer when one considers, well, what is the purpose of the consultation? And for that, refer again to Lord Reed's judgment in Mosley, and if it helps, we can turn to it. But at paragraph 39, paragraphs 38 and 39, Lord Reed, it may help to just turn to it, just so we have it, but it's behind tab 12 of the authorities bundle, and it's page 301. And Lord Reed notes, just for your note, at paragraph 36, the variety of types of statutory consultation that we have. One can have a statutory consultation that identifies very specific individuals that need to be consulted, or you can have a very broad consultation like this, which is just public. And then at paragraph 38, Lord Reed held that the wide-ranging consultation in respect to the exercise of local authorities exercise the general power is far removed from the context and scope of situations in which the common law has recognised procedural fairness. And then further down, just at E of that paragraph, the purpose of this particular statutory duty to consult must, in my opinion, be to ensure public participation in the local authority's decision-making process. And then at paragraph 39, considered that participation had to be meaningful, because not only, and that was followed from the general obligation just above G, that consultees should know what the proposal is and exactly why it is under positive consideration, telling them enough, which may be a good deal, to enable them to make an intelligent response. And that is the principle that we say Mr. Justice Swift properly applied in considering this consultation. And so, going back to the statutory context, what is it here? Well, here we have a wide-ranging public consultation. There is no narrow cohort identified within section 113. It concerns the exercise of local democracy that has a direct effect on all those living and working in the area. And here the area, of course, is the West Midlands. And it concerns who is ultimately responsible for the policing budget and for holding the Chief Constable and their police force to account, the role of the Police and Crime Commissioner. And so that is something that does directly affect those living and working in the West Midlands. And then looking back at section 113, the statutory tests at A and little a focus on those living and working in the area. And so it does therefore focus the Secretary of State's mind of not is this just a general benefit that the government wishes to pursue as part of its overarching policies, but is this something that is of likely benefit to those living and working in the area under consideration? And in our submission, the purpose behind that is clear, because it is the Secretary of State, of course, making this decision. So it's a decision being made at the level of central government. It is not a decision being made by the combined authority or constituent council, who have local and day-to-day experience of the issues in the area. And so it's inevitable that the decision maker here, under 113, is a level removed from the day-to-day workings and life in that particular area. And so therefore, in our submission, the reason why Parliament therefore focused the tests on the local area is because obviously those are the people being impacted, and then impose a duty to consult to enable those who are being impacted to provide their views and the information on the tests that the Secretary of State has to apply. To say, well, actually, in the West Midlands, it's not going to be of economic benefit to us because these are all the various local issues that we consider are relevant to that. Or it is, because we consider that the ability of a mayor to join up one particular part of the mayor's responsibility with the police and crime commission's responsibilities will bring great social benefits for these reasons. And so when one looks at section 113 in the round, as Mr. Justice Swift did, in our submission, it's clear that the purpose of the consultation is to enable the Secretary of State to have the views of those who are going to be affected, to enable him to satisfy himself whether or not the statutory tests are met. But if he doesn't ask the consultees to address the statutory tests, and he doesn't provide them with his preliminary views and the relevant information that he considers goes to those tests, then they are not participating meaningfully in the decision-making process. They are instead, on my learned friend's case, being invited to comment on some very high level apparent benefits that are not necessarily directed at the individual lives of those working and living in the West Midlands. And then leaving it to the Secretary of State, or those that advise them, to work out of all those responses whether or not they assist or don't assist in the application of the statutory tests.
And what about Mr. Payne's point, which is that if you look at the responses that came in, you can see that they were asking themselves the right questions and able to engage effectively?
My Lord, there are going to come to that later. But
Oh, sorry.
No, I'm happy to address it. Now there are there are three broad points that I would make in response to that. One, if the correct questions weren't asked, then we simply don't know whether or not the consultees had anything else more to say. The Secretary of State is pains to point out how many people responded to this. 7,000 people compared to circa 4,000 who responded to the South Yorkshire consultation. That shows a degree of interest in this issue. And that doesn't absolve the Secretary of State from providing proper consultation. It emphasises almost why it's more important to do so, because there is active interest in the West Midlands in this issue. And so, my Lord, the first point is that the fact that some people might have alighted upon it doesn't mean that the consultation was sufficient, because you don't know what other people would have provided had they been asked the correct questions. And if we do say that it is of note that on that point there's no appeal on Mr. Justice Swift's decision that he should refuse relief under, or dismiss the claim under Section 31 of the Senior Courts Act, because the decision would likely be the same. The second point, my Lord, is when one actually looks at the statistics, and these statistics are calculated by us before Mr. Justice Swift, we were provided in a couple of days before the hearing with a 6,000 entry Excel spreadsheet of a summary of the consultation responses, which is what we worked through at a degree of pace. But in that spreadsheet, they had, the Home Office had identified how many of the responses they considered went to each of the statutory tests. And so doing, thankfully, a very simple exercise of just filtering out the yeses and the nos, one could work out what the numbers were. 312 responses out of over 7,000 were thought to go to the economic question of economic benefit. 12 went to the question of support for environmental well-being. That's 0.16% of the responses engaged in that element of the statutory test. The highest is economic benefit at 4.5 in terms of the test under A, and that's 4.5% of the responses engaged in statutory tests.
Is that your interpretation of them, though? You've decided to classify certain things as responding to the economic benefits, or does this 4.5% have some kind of external validity?
And that's the Home Office's classification.
That's the Home Office
Yes.
classification.
We were I did the exercise, so all I did was in this ginormous spreadsheet there are columns to indicate whether or not they consider the response to the economic benefits.
Oh, I see. So they
Social
linked them up to the criteria.
with a yes or no.
Okay.
And
So what you've done is you've done the maths from their spreadsheet.
I filtered out the blanks and the no's and counted out the number of yes, or Excel for me has counted out the number of yeses.
And strictly, do we have the spreadsheet? I mean, are you giving evidence, or I mean, just to follow? I know it's old-fashioned, but
my lord, entirely. We don't have. Well, we haven't been served with the spreadsheet. We put those figures in our submissions before Mr. Justice Swift. They've never been disputed, and they've been adopted by my learned friend and his certain argument. But I'm afraid I don't have that in evidence format. And if the third point, my lord, on this is actually if we look at some of those consultation responses, and this I probably will reserve to come in when I come back onto the facts, is that we can show that actually the consultation, the consultees responded on what appears to be a misapprehension of what the actual position would be. In particular, the number of consultees who responded thinking that this was going to lead to an efficiency by combining roles and therefore saving money, and we say that that's not correct.
how can we judge that? You're telling us that you think that, and it may not even be relevant to the decision that we've got to take. But how can the Court of Appeal take a view on whether or not the people might have thought they were answering a different question? What's the basis for this court, which is a court of law dealing with evidence, to accept that submission?
My lord, yes. So that was my that was my third point in response to my Lord Justice Dingemans' question in relation to what is my answer to the Secretary of State's assertion that, well, if you look at the consultation responses, this shows that there was enough engagement in the issues, and so therefore this was all sufficient.
Okay, so he can say they're good enough, and you can say, well, if he can say they're good enough, I can say they're not good enough. Right, okay.
Well, my first point, my Lord, in response was the point that my Lord just put to me, that if you don't ask the right questions, you don't know, and so therefore you don't get to it. But as an alternative position, if one is saying, my learned friend relied on the 5th of February submission to the Secretary of State, and he drew my Lord's and Lady's attention to paragraph 9 and 10 of that submission. So my Lord, just for a notice, core bundle 205, where those percentages are set out, and he identifies what he says. He says, well, that supports my argument that this was a good enough consultation, because you have 16% of individuals mentioned the opportunity to rationalise public resources. When in fact, if there had been a proper consultation, we say, with the facts properly explained, we say you wouldn't have got that position because you don't rationalise resources. In very brief, the rationalisation of resources is said to be in the material. You don't know, you're no longer paying a PCC salary, so therefore you're saving a great deal of money, or some money. But the reality is you don't pay a PCC salary. The mayor gets an uplift in their salary, which is takers, because they're taking on more roles, and then the mayor's going to appoint a deputy mayor for policing, which will therefore require a salary because it's a new member of staff to carry out PCC's functions. So all that was explained in the consultation process, because the Secretary of State considered that that type of information was relevant to whether or not there was going to be an economic well-being. You would have had engagements on those issues, and therefore it was likely that you wouldn't have people saying, well, this is a great idea because it's going to get rid of us having to pay a public official. So that was a very long-winded answer, my lord, to your question. Can I turn just to section 112A, which Mr. Justice Swift considered supported his reading and interpretation of the context of section 113, and we respectfully submit is correct. My learned friend advanced the argument, at least, and I may well have misunderstood it, but it's section 113, subsection 2. He advanced the argument that the Secretary of State had a discretion to rely upon a consultation that wasn't connected to anything to do with the tests under section 113 by relying on section 113.2 and subsection B. But I mean, my respectful submission, that misses the and at the end of B and the conjunctive nature of those three subsections. So that is section 2 only concerns circumstances where a Secretary of State has received a proposal under section 112A. Received a proposal, the consultation was carried out in connection with that proposal as is required, as we've seen from 112A, and the Secretary of State then considers that it's not necessary. And the point, the point in our submission that makes that supports Mr. Justice Swift's understanding of section 113 in relation to 112A is it's abundantly clear, as we've seen, that 112A requires a consultation on the proposal that the local authority are considering to make. When they are making a proposal under section 107F, it would be very sensible of them to address the tests that the Secretary of State hasn't, in fact, to address, and therefore might consult on those points. And once they've done the consultation, they finalise their proposal, and they transfer it to the Secretary of State to make a consideration. Now, at that stage, the Secretary of State has a discretion of whether or not he does or doesn't consult. If he looks at it and considers that the local authority has done a very good job, consulted on the statutory tests and have the information that I need, then the likely answer is to be, I don't need to do this for a second time. But the fact that it's a discretion envisages the fact that the Secretary of State might receive one that is deficient, that doesn't, for example, address what he needs to turn his mind to, which are the statutory tests, and concerns some broader questions that the local authority were concerned about when they were deciding to make this proposal. And in those circumstances, he would have to carry out a consultation, because the consultation wouldn't be, to use the words of 3.2c, well, it wouldn't be sufficient, so the consultation, a further consultation would be necessary to ensure that his decision under 113 is lawful.
Increasingly, I wonder if this is statutory consultation, and the question is, what does the Secretary of State have to carry out a public consultation? When it's a 112A situation, we know it's a proposal to make an order, because we know the local authority can't make the order. All they can do is propose it. And they propose it, they consult on it, and then they submit it. But the proposal must be linked to the statutory criteria, even if it covers other things as well. And then you go to 113.2, and there is the ability to make an order. He doesn't have to make a proposal first, because he's the Secretary of State, he just makes the order. But when it comes to 113.2, is it a consultation on what he is proposing to do, which by definition will include the statutory criteria, or is it a public consultation in the abstract, i.e., would there be benefits on doing this if I'm allowed to do it? If it's the former, it's a consultation on what he's proposing to do, then arguably it's meant to include information governing the reasons which allow him to do it. If it's a consultation in the abstract, would there be benefits in doing this, brackets, if I'm allowed to do it, close brackets, then it would be a different thing. And the key question perhaps is what 1132 on its wording and in context means. But I had thought that Secretary had accepted it was a consultation on a proposal, in effect a proposed course of action.
Well,
Or
yes,
that's not a right analysis.
but in my submission, it is. It's the public consultation on the proposed power,
The proposed course
proposal
of
to
action.
exercise a power under Section 107F, and I've already advanced submissions on why that therefore must be.
There's a
That's the
so it
point.
must carry a public consultation on a proposed course of action, possible abolition or transfer, and by definition, you say that must bring with it questions about would this meet the criteria and information to enable the people comment on that. So
Yes.
it's a consultation on a proposed course of action, not a consultation on benefits, which, if the action is allowed, would be desirable.
Because, and the reason for that, my lord, is because there has to be meaningful public participation in the decision-making process.
Yeah.
And the decision-making processes here is not, I think this might be of general benefit. The decision-making process here is, I have to satisfy these statutory tests, which Parliament has specifically made to focus on the impact of you and the local area that I'm making this decision about. And
You
I have
say
to
the
consult.
structure of the section which starts with the order and then the consultation, and you say the purposes of the order, and the respective roles of people. You say all of those are further indications to why this statutory provision means consult on the proposed course of action, and you define the sufficiency information and the questions to be asked by reference to that. And you say this document just didn't even begin to do that.
Yes. And my lord, you have, of course, the requirement to do consultation is not only in 2, but is in 1 little b. So the statute has to be met and you've undertaken the consultation. And so then that's where you get, that's how you then get to 2. And so it's combined in this combination of this is the order you're making, these are the statutory tests, they are focused on the local people, and you've got to consult about it. And if you're going to engage them meaningfully in that decision-making process, you need to do so.
It's not on high-level benefits or on views, it's about the proposed course of action.
No. And my lord, my lords and ladies, just on then that point on sorry on the so the point that my learned friend was making, that it was sufficient to undertake a consultation on the broader benefits, was essentially, as I understood it, down to the fact that the broader benefits had, in effect, were the things that had been thought of, and they hadn't actually turned their minds to the statutory tests. That is a consequence of the fact that they decided to launch this at pace in a desperate attempt, we would submit, to still achieve a transfer of decision in time for the May elections. That has no bearing, we would submit, on whether or not the consultation was or was not unlawful. It may be an excuse and a reason for why they didn't get it right, but it's not. It is no relevance to whether or not this consultation was or was not. Because, of course, they could have given thought to that. And just one point on the in response to my learned friend's submissions about how vague the financial information was, and he took my lords to the West Midlands statutory decision, where they raised the fact that they thought that this was likely to cost them in the region of £3 million, and that's the supplementary bundle 312. That information, of course, was dated. That notice was published, as you'll see, on the 11th of December. So that's 9 days before the consultation was launched. So they were, or at least could have been aware that the West Midlands thought it was going to cost them in the region of £3 million. We don't need to turn to it, but it's paragraph 47 of Ms. Chapman's statement, which is page 252. That's where she identifies the government's own estimate of the costs, which is 1.3 million per election. What isn't there is a date, and my friend will know that correctly if I've missed it, but a date when those calculations were made. But what we do know, because we were pushing for appropriate disclosure in this case, it was expedited, of course, not only in these proceedings, but it was expedited before Mr. Justice Swift. We do know that in December there was correspondence between the Home Office and the West Midlands Combined Authority as to the financial costs, and we get that at page 386 of the supplementary bundle. And you'll see paragraph 4 of that letter from the Government Legal Department confirming that there was discussions via email with the West Midlands Combined Authority, and the Home Office in relation to costs. And we were provided with those emails. They haven't made their way into the bundle, and I'm not going to seek necessarily to put them before the court now. But the point to make is that these discussions were being had. The Home Office were aware of these costs, and there is no reason why, if they considered, which they did when we look at the statutory reasons, that it was relevant to the question of economic well-being, why was it in the consultation? Why are we not informing the local people that 3 million, this might cost anywhere between 1.3 and 3 million per election? We'll see that the Home Office uses a 9-year cycle in their economic notes, which in this case takes into account 3 elections. So that's between 3 and 9 million over that cycle. The information people would have wanted to know when they are knowing that this is the potential cost of this, and whether or not it is therefore in their economic well-being to do it. It might be a relatively small amount in an overall combined authority's budget, but in days when services are constantly being cut, it is a point that the 2.8 million people of West Midlands, or the 7,000 who engaged in this conversation, might have had something to say about. And the fact that it wasn't said because they hadn't thought of it necessarily isn't entirely correct, when they indeed were having these very discussions in the lead up to it.
Mr. Stensfeld, I know that certainly one member of the court has a particular professional obligation during the short adjournment, so if it's convenient to you, can we stop now?
Very convenient. I was about to
Just about to do it. All right. And this is probably a really unfair intervention on my part at this time, but given you've been on your feet for about half an hour or so, how long do you think you're going to be?
I can probably finish in response to my learned friend's points in about 15 minutes.
Let me make one thing clear. There's no pressure of time on you. I just wanted to have an indication.
I think that's probably 15 minutes. First, I'll say 20 because
why don't you?
Timing accuracies. The tradition of the bar is never good.
All right. Thank you very much indeed. 2 o'clock then.